والحمد لله رب العالمين والصلاة والسلام على رسوله الأمين وعلى آله وصحبه الطيبين الطاهرين. أما بعد، فإن أصدق الحديث كتاب الله، وخير الهدي هدي محمد صلى الله عليه وسلم، وشر الأمور محدثاتها، وكل بدعة ضلالة. ثم أما بعد، أيها الأحبة الكرام، السلام عليكم ورحمة الله وبركاته. Inshallah, from today we'll be talking about the ways of ending a marriage contract. As we discussed before, that marriage is prescribed by the Sharia as the only lawful union between a man and a woman, based of course on mutual consent. And ideally, the purpose of marriage is to bring about or to foster a state of sakina, which is tranquility, and love and compassion. But this is not always the case. Conflicts, problems, might arise between the two spouses, and those conflicts might trouble their marriage. And of course, the two spouses, as we talked, especially last week, the two spouses must try hardly to reconcile and to solve and resolve their conflicts and their problems. And last week, alhamdulillah, with a contribution from every one of you, we talked about different ways and strategies to solve and resolve marriage conflicts. But if reconciliation and trying to resolve the conflict fails, of course, separation might become inevitable. And also, and the Sharia granted for the two spouses, the wife and the husband, granted to them, separation, established, of course, on the basis of the Sharia, or as regulated by the Sharia. So inshallah, we're going to talk about separation or ending a marriage contract, and the rules and the regulations imposed by the Sharia. But separation must be the last resort. To be the last resort. So what are the ways to end a marriage contract in the Sharia? To end a concluded marriage contract in the Sharia, there are three ways to end a marriage contract. The first is al-talaq, which is divorce. Al-talaq, which is divorce, and primarily, talaq mainly is initiated by the husband. The second way to end a marriage contract is called al-khul'. Khul' is to end the marriage contract, or in fact, ending a marriage contract from the wife's side by a request from the wife, or initiated by the wife, when the husband is not at fault, but it's initiated by the wife in return of a compensation. A compensation, either to give him back the whole mahar or part of it, or more than the mahar, as they agreed. So it's a way to end the marriage contract, but it's initiated by the wife. Or also it could be requested by the husband. But it must include a compensation, or in return for a compensation paid by the wife to the husband to end that marriage contract. This is called al-khul', and this is the second way to end a marriage contract. And the third way is called al-fasakh. Al-fasakh means to annul or invalidate the marriage contract. And al-fasakh is, in fact, is a judgment. It must be a judgment by a judge in the court of law, a Muslim court of law, for many reasons. For example, if the husband abuses his wife, or if he fails to cover her nafaqah, then she has the right to ask for fasakh. But as I said, the fasakh is a decision, must be a decision made in the court of law. So those are the three ways to end a marriage contract. Inshallah, I'm going to talk about them in very detailed manner. And we're going to start first talking about al-talaq. talaq, which is the first way to end a marriage contract. At-talaq, literally, at-talaq is ismu masdar, is a verb and noun from the word talaqa or talaqa. Okay, and talaqa as a word, or talaqa, means to set free or to release. If you remember when we studied usul al-fiqh, we talked about al-mutlaq wal-muqayyad. So mutlaq or talaqa is opposite of qayd. Qayd means chain. If someone is chained, it's called muqayyad. Okay, when you set him free, we said atlaqa saraha, or that he set him free, or he released him. Okay, so at-talaq literally means to release or to set free. طيب. As a technical term, هو حل عقد النكاح أو عقدة النكاح بعضه أو كله. حل عقدة النكاح. You know, we said عقد or contract in Arabic means to tie tightly. Okay, so now as if the two couples are chained together. Now, to break that chain and set them free is called talaq. Either partially or to حل العقدة completely, to separate them, complete separation. Okay. So when we say partially, this is referring to the so-called الطلاق الرجعي, the recoverable talaq. And when we say completely, to separate them completely, this is refers to الطلاق غير الرجعي, which is the irrecoverable talaq. And inshallah, I'm going to talk in a minute about those two different types of talaq in a detailed manner. So this is the definition of talaq. حكم, which is the ruling or the status or the ruling concerning talaq in Islam. According to the majority of the scholars, الطلاق مكروه, it is disliked. Okay, but some other scholars, they get into details and they said talaq could be haram, or it could be makruh, and it could be mubah, permissible, or recommended, or sometimes it becomes an obligation and a wajib. An example of a situation where talaq would be a wajib or an obligation is the so-called al-ila. Al-ila, this is called talaqul muli. Al-ila is if the husband took an oath that he will not have relation with his wife. Now, if such thing happens, then he would be given 4 months. When those 4 months expires, he either go back and have relation with his wife, or he will be forced to divorce her. This is the case where talaq becomes an obligation upon the husband to do. If he took an oath, he swore by Allah not to have relation with his wife, he has up to 4 months. After the expiration of the 4 months, then he either, make the kafara for that oath and have relation with his wife, or he will be forced to separate from his wife, to divorce his wife. Okay? Or it could be recommended if the wife fails to observe some of the rights of Allah. Of course, he is encouraged to keep her, and also, try to correct her and bring her back to the straight path. But if he fails, he is recommended to divorce that woman. Sometimes it becomes permissible if there is a need. Okay, sometimes it becomes makruh or haram. Haram. Example of a haram divorce is to divorce his wife while she is in her menses or having menstruation. Okay, or to divorce his wife without any legitimate reason. According to Sheikh Al-Islam Ibn Taymiyyah, this situation is haram to divorce one's wife. Okay, in fact, the position held by Ibn Taymiyyah and Ibn Al-Qayyim and some other scholars, that the general rule concerning talaq, that it is haram. It's haram to divorce one's wife unless there is a need to do so. Now, so this is regarding the status or the legality of talaq in Islam. Unlike some religions, other religions, or some other factions in some other religions that prohibit divorce. Divorce is not something good, but sometimes it might be the only resort, to end a marriage contract. Now, and it could be also, for the benefit of the wife, because sometimes it might be the only way for that wife to lead a good life is to separate from that husband. So if there is a need, a legitimate need to divorce, then divorce is acceptable and it could take place. There are different types of divorce, of course, according to the different perspectives. Okay, for example, if you want to classify or categorize talaq in accordance to whether it is recoverable or not, we have two types of talaq. The first one is called al-talaq al-raj'i. Al-talaq al-raj'i, this is a type of talaq in which the husband has the ultimate right, okay, to get his wife back without a new contract, without mahar, and even without her consent. This is called the recoverable talaq or al-talaq al-raj'i. It's a talaq in which the husband still has the absolute right to get his wife back, okay, and without a contract, without a mahar, and even without her consent. This is if he divorced her once, or it is the second time to divorce her, while she is still in her iddah. Because once the husband divorces his wife, she has to stay at her home for an entire period of iddah, which is 3 menstruations. Okay. Now, during this period, if this is the first time or the second time to divorce her, he has the right to get or to return her back without her consent. Okay. This is called al-talaq al-raj'i, which is the recoverable talaq. الطلاق غير الرجعي, which is the opposite of that, in which the husband does not have the full right to get his wife back. And we have two subdivisions of this الطلاق غير الرجعي. Okay. The first type is called البينونة الصغرى, or the minor irrecoverable talaq. This is when a husband divorces his wife the first time or the second time, and then after the expiration of the iddah, after her iddah is expired, then the only way for him to get his wife back is through a new marriage contract with mahar and with her consent. She can say yes or not. Still, he has a right, but that right is limited. Does not have the absolute right. Okay, they have to have a new marriage contract. Okay, with her consent. She can say yes and she can say no. This is the first type of irrecoverable talaq, which is the minor irrecoverability, which is called al-baynuna al-sughra. The second subdivision is al-baynuna al-kubra, the major irrecoverable talaq. And this is when he divorces his wife for the third time. Now, if he divorces his wife for the third time, then he cannot get back to that wife again. There is only one exception. If that wife gets married to another husband, and they consummated the marriage, not only they have a contract, no, she gets married again with another man, and they consummated the marriage, means they have sexual intercourse, and then that second husband separated from her either by divorce or khul or by death, then and only then the first husband can remarry that woman again. This is called al-baynuna al-kubra. So the first subdivision of irrecoverable talaq is the minor, or the baynuna sughra, the minor baynuna. And this is when he divorced her the first or the second time, and after the elapse of the expiration of the iddah. And also there is another case here, I forgot to mention it. If he divorces his wife, before consummation of marriage, like he get married to her, and before consummation of the marriage he divorced her, this is also considered to be as minor bainuna, because immediately, they will be separated, and she does not have the right to get back to that wife, unless with a new marriage contract and a mahar, and she has to say yes or no. Now, so those are the two types of talaq. If we divided talaq in accordance to whether it's recoverable talaq or irrecoverable talaq. Okay. Now, there's another way to divide talaq in accordance to whether it is in accordance to the sunnah or not. Now, with this respect, we can divide talaq into three types. The first one is called talaq al-sunnah, or the sunnah talaq, or the sunnah way to issue talaq. Okay, and this is if the husband divorces his wife, okay, after the wife's ministrations comes to an end, okay, and she's pure now, and before having any sexual relation with her, okay, then he has to divorce her at that time, in order for this talaq to be a sunni talaq. Again, if he wants to issue a sunni talaq, he must wait until the wife's menstruation comes to an end, and then while she's in that state of purity, and before having any sexual relation with her, he must divorce her at that time. Or if he divorces his wife while she's clearly pregnant, this is also considered to be a sunni talaq. Okay, this is the first type of talaq, and this is a proper way to divorce one's wife. Either to divorce her في طهر لم يجامعها فيه, to divorce her while she is pure from menstruation and before having any sexual relation with her while she is in that state of purity. Okay, I'll give you an example. If, for example, her menstruation is over and she is now pure and she took ghusl, okay, now before having any sexual relation with her, then he has to divorce her at that time, if for a valid sunni talaq. Or if she is pregnant and clearly pregnant, like in her 3rd or 4th month of pregnancy, and then he divorced her, then this is also considered to be a valid talaq, or a sunni talaq. The second type is the bid'i talaq, or talaq al-bid'ah. Talaq al-bid'ah is to divorce a woman when she is in menstruation, or she is in her menses or cycle. Okay, or to divorce her when she is pure, but after having sexual relation with her during that period of purity. This is called talaq al-bid'ah. Now, the third class is a talaq, which is called la bid'i wa la sunni. It's neither nor. We cannot call it sunni talaq or bid'i talaq. This is like divorcing a woman who reached the age of menopause. The age of menopause, when she reaches an age when her menses cease or permanently stops, like usually between the age of 45 and 55 or 60, when women have no menses anymore. Okay, so here he can divorce her anytime. Okay, there is no restriction because there is no menses, and her iddah would be with months. And she has to stay, her period would be 3 months. Unlike women who still have menstruations, their iddah is for 3 menstruations. So the first talaq is called talaq al-bid'ah. The second is the first one is talaq al-sunnah. The second is talaq al-bid'ah. And the third, a talaq that we cannot call it neither nor. It's neither bid'ah nor sunnah. What's the ruling concerning talaq al-sunnah? Talaq al-sunnah is a valid talaq. Okay, if a husband issued talaq in accordance to a sunnah, or as we described, that he divorced his wife either after her menstruations is over and before having any relation with her, or when she is clearly pregnant, this is the valid way to issue talaq, and it's a valid talaq. Talaq al-bid'ah is to divorce his wife, as I said, while she has menstruation, for example. Now, according to the four imams, according to Al-Imam Abu Hanifa, and Al-Imam Malik, and Shafi'i, and Ahmad, according to them, two things will happen. First of all, that husband will carry a sin because he performed improper talaq. Improper in the sense that he is prohibited to divorce his wife at that time, but he divorced his wife. Okay, so this is a disobedience to Allah subhanahu wa ta'ala. يا أيها الذين آمنوا إذا طلقتم النساء فطلقوهن لعدتهن وأحصوا العدة. Okay, and Ibn Abbas and other Sahaba, they said this ayah means if you want to divorce your wife, divorce her while she is pure before having a relation with her, or while she is clearly pregnant. Otherwise, it is not in accordance to the way of the Prophet ﷺ. So, the first thing, that the husband will carry a sin. Secondly, according to those four imams, this talaq is counted. It is counted, and it is a valid talaq. They count it as a valid talaq. Okay? According to some other scholars, among the Sahaba, and among other imams and scholars, and this opinion is favored by some great scholars like Sheikh Ibn Taymiyyah and his student Ibn al-Qayyim, and some of contemporary scholars, that the sin, the husband, he will carry the sin and he has to repent to Allah subhanahu wa ta'ala, but the talaq is not counted. And this is a very complicated issue. Okay, and the evidence are very, you can say that the evidence is used by both sides are very close, and there is no way to say the safest opinion is this or that. Okay, it's not an issue where you can say it is the safest opinion to go with the opinion that says it is a valid talaq. Also, you cannot say it would be safe to go with the other opinion that says it is an invalid talaq. This is a very important issue, and many scholars, they said every single talib ilm, okay, or anyone, he has to investigate and do his homework and try to figure out which one of the two opinions is the stronger opinion. You might favor an opinion now, but with more reading, you might find out it's not the right one, then you should leave it. And some of great scholars like Imam Shawkani, it's a scholar in Yemen about a couple of 100 years ago. He's known in his ilm and scholarship. He was very hesitant in that issue. Sometimes he, his opinion that it is a valid, and some other times it's invalid. So a person who get in that, he must, search the issue very well, and then after that he would go for the opinion that seems to him that it is a stronger opinion, because as I said, the proofs are very close, the evidence used by both sides. Okay, now this is regarding the hukum or the ruling concerning talaq al-bid'ah. Okay, I forgot to mention one thing about talaq al-bid'ah. Talaq al-bid'ah, as I said, either to divorce the wife during menstruation or while she is in her purity, but after having sexual relation with her. There is a third example here. If he divorced his wife 3 times with one word, like he says to his wife, you are divorced 3 times. This is improper. Or you are divorced, you are divorced, you are divorced. This is also improper, and it is a bid'i talaq. Okay, it is a bid'i talaq, because the proper way, as I mentioned, to divorce her just once at that proper time. Okay, if you want to divorce her the second time, then he must, retain her back first. Okay, and then issue another divorce, but not while she is in the iddah of the first divorce. Okay, if that happens, this will be a bid'i talaq. This is another way to divide talaq into, in accordance to, whether it's in accordance to the sunnah or not, to divide it into those 3 types. Type who, let's go through this mas'ala. Who is the one whose talaq is considered to be a valid talaq? Or what are the conditions for a valid talaq? Of course, the valid talaq must be initiated by the husband or the representative of the husband. Okay, a husband can delegate someone to be as his representative to divorce his wife. Some scholars, this representative can be his own wife. He can give her the authority to divorce herself. Some of the scholars, they said this is against the objective of the Sharia, because Allah subhanahu wa ta'ala gave the authority to initiate the talaq to the husband, because generally men were expected to be more wise in using that authority. Unfortunately, sometimes this is not the case, but in general, men are expected to be the wise people. Okay, if talaq is granted to women, they might divorce, the husband in the first night of marriage. Okay, because sometimes many women, they are very emotional and they might. This is why Allah subhanahu wa ta'ala gave the authority to the husband. So some scholars, they objected to the case that when a husband gives the authority to the wife to divorce herself. But according to many scholars, that is acceptable, to give that authority to a representative or to his wife to divorce herself. Inshallah, we'll talk about the representation in talaq, which is called al-wakala. It's similar to the wakala in business contract. We'll talk about it also in great details later on, inshallah. So the first condition, that the one who issues the talaq must be the husband or his representative, not the father, the husband's father, not his brother. Okay, unless he was assigned or appointed by the husband to be the representative. Also, the zawj, or the one who issues the talaq, the husband, must be baligh, an adult of course, and sane. Okay, if he's insane, his talaq is not counted. Now, if someone who intoxicated, okay, a sukur, in Arabic it's called a sukur, if someone drank khamr and he was intoxicated, and then he divorced his wife while he's intoxicated. Now, the scholars differentiate between two cases. If that person was forced, to drink liquor, or he get intoxicated against his will. Okay, they just mention this probability, which could be very remote. But if that's the case, his divorce will not be counted, and this is the unanimous consensus of the scholars. But if he willingly, drank and become intoxicated, and then he divorced his wife, we have two opinions among the scholars. Some scholars, they said his talaq will be counted because he did that action willingly. Because if that one who is intoxicated killed somebody else in a car accident, he will be held accountable. Okay, and if he damaged anyone's property, he will be held accountable for that. So they said we will hold him accountable for his talaq and it will be counted. Okay. Some other scholars, they said he lost his, sense of, and he's not in a state legally that he can be aware about what he's saying. So according to them, his talaq is not countable. Another thing, mas'ala which is related to this, if someone divorced his wife while he's in state of anger, ghadab, okay, right. If he is really mad, sometimes a person might reach a state of anger that even he is not aware about what he's saying. If he divorced his wife at that time, according to the unanimous consensus, the ijma' of all the scholars, his talaq is invalid. Okay, this is one scenario. Another scenario, if he divorced his wife, he is angry, but it's a normal anger. Okay, this according to the unanimous consensus of the scholars, his talaq is counted. Because no one will divorce his wife while he's smiling. He must be in some type of anger. Okay, but it's reasonable anger. If his anger is in between, okay, now this is where we have a disagreement among the scholars. Some scholars like Ibn Taymiyyah and Ibn al-Qayyim and others, they say that he's very angry, okay, then his talaq is not counted, because Aisha radiallahu anha narrated a hadith that the Prophet ﷺ says, La talaqa fi ighlaq. Ighlaq means if someone, ighlaq literally means lock or locking, as if his mind, as his aql is locked. And this is why he issued that divorce. His anger reached a level that, he abandoned his mind and he just issued it. So according to those two great scholars, his talaq is not counted. Inshallah, this is just an introduction to separation or ending a marriage contract. Inshallah, starting our next lecture, we will be talking more details about talaq and the other methods of ending a marriage contract. سبحانك اللهم وبحمدك أشهد أن لا إله إلا أنت أستغفرك وأتوب إليك وصلى اللهم وسلم وبارك على محمد. جزاكم الله خير إن شاء الله.